Okay, are we live on LinkedIn right now? Oh, right now, live. We are. I just got a notice on LinkedIn. It's true. Okay, let's see if we've got some folks joining us. And looks like we've got some folks joining our webinar. We've got a few folks coming on right now. We're just going to be ready to start in about 6 minutes. And we'll see what happens with this. Okay, good morning, everyone. If you're joining us today, we are my name is Michelle Herman, and I am with Hayako Academy, and we are very excited to kick off the first of 6 sessions that we're doing this week. And this program is actually the launch of a brand new program for Hayako, where this is actually a mini certification course. So these live courses that you're going to be seeing this week are going to be part of a program that will enable you to actually get a mini certification along with a certification of completion for these courses. So we're really excited to kick off this program. And we've got a few more minutes until everybody loads up here and comes on board. We've got a few minutes. And let's see. Wanda, how you doing?
I'm doing fine today. How are you doing?
Doing fantastic. It's always great to have you in these events. You're always welcome. And B80, we are so excited to have you involved as well. How are you doing today?
I'm doing great and glad to be here.
We're excited to kind of mix things up a little bit. We've of course had Wanda on so many times before. She's been a phenomenal addition to the Hayako training program, and we are excited to bring in you and First Corporate Solutions into this. And we are looking forward to all kinds of great stuff in the future. So thanks for joining us. Okay, got a few more minutes to go. Beata, how's the weather out there? Where actually are you located?
I'm in Washington, South Puget Sound, and the weather's nice. We actually have some sun today, so in the 70s,
fires,
beautiful.
No fires or snowstorms or anything crazy like that?
No, we had some smoke last weekend, but that's all cleared out, so much better.
Awesome. And Wanda, how's the weather where you're at?
Actually, it's a beautiful day today. It's going to be low 80s and drops down to the 60 at night, which is typical September for us, and great sleeping weather. We've been able to turn our air conditioners off and open our windows.
Nice. Yeah, it's nice to finally get to that.
You can't say that yet, Michelle, can you?
No, not yet. In fact, I think it dropped down to 60 degrees last night here in Albuquerque. But it was for like just a couple hours, so I had the air conditioning on all night. So not quite there yet.
The only problem with turning off the air conditioners, of course, is that you can't, once your windows are open, you're going to be awakened by all the outside noise. You can't sleep in.
Exactly. That's the challenge for sure. And then we have Caroline Anderson on with us too, right? Carolyn, are you here?
Yes, I am. I am looking forward to this presentation.
Well, we are happy to have you here, and I think this is going to be a good one, no doubt. Lots of good stuff.
I think so. I think we've got a great panel, and this should be very, very interesting.
Excellent. And looks like we've got some folks that have joined already. And anybody who's joined, if you want to throw in the chat box where you're dialing in from today, what company and what part of the country. We've got a few folks, but they all say the same name. So we might have a little technical challenge here. Okay, our folks in India. You want to check our participants at this point? If we've got a few more folks coming in, but I can't see anybody's name, so I'm not really sure exactly who's in. So,
Yeah, I know. I noticed that. Oh, there we go. Now it came back.
okay, we've got some folks showing up.
Now I can see the participants.
Oh, here we go. Okay, we've got Chris Cerruti is in. Hey, Chris, glad you could make it today. Yeah, looks like we've got a few more folks coming in. We'll wait another minute or two as some folks join. Looks like we're off to a little bit of a slow start here this morning. But those of you who are on LinkedIn Live, again, we're very happy to have you today, which is the first of 6 sessions that we're doing live this week. And this is part of our mini certification program launch at Hayako Academy. And I'll talk a little bit more about it once we get started. And what we've done historically, if you're new to Hayako, or if you've been involved for quite some time, what you may have noticed already is that literally everything that we have that's on our site, every session that we've done in the past, for the past, I guess, about 2 years, has been absolutely free of charge. And that process is going to continue. We're very excited to really be, I don't know, I guess, is it the world's first repository of video tutorials on the credit and collections industry? And we are now up to over 150 courses. All of those are free of charge. We're in the process of bringing over all of the content from the Credit Today platform. We purchased Credit Today about 2 years ago, and we're adding information, articles, surveys, tutorials, checklists, all kinds of things from the Credit Today platform. So as we do that, we're creating more and more content. And one of the key things that we wanted to do here is, well, we've had a lot of requests for even more detailed types of training. So the trainings that we've done, when you go to our website, you'll see there's sessions that are anywhere from 15 minutes up to 6 hours. So, and everything in between. But we've had requests to get more in depth, and people are actually asking for more acknowledgement and more recognition, things that they can actually carry with them on their LinkedIn profile that can add to their career progression. And so what we're launching on this particular event is the mini certification program. And it's about 1 or 2 after. So I'm going to just go ahead and get started here. And looks like we've got a few more folks that have come on in. Glad to have you. And okay, so today, again, the title of this course is Swim Through the Good, the Bad, and the Ugly, UCC War Stories. And we are very, very excited to, of course, have the illustrious Wanda Borges with us, who's been with us many times in the past and is well known in our world of credit collections. And we are happy to have a newcomer, Beata Egloff, and she is from a company called First Corporate Solutions. And we are thrilled to have this company involved and Beata involved with us. She brings an incredible amount of experience, as does Wanda. But before I get into that, talk a little bit more about Hayako. Again, if you've not logged on to hayako.com, please go there today. You can sign up, get a free account. You'll get access to all these tutorials. I think we're up to about 250 different video segments. And the program that we're launching today, uh-oh, someone's changing my slides.
Yeah, no, that was me.
Oh, okay, great. We're figuring out our remote.
Yeah, my controls seem to be playing games, but that was me.
Okay, all right. I'm gonna. There we go. This is our first remote control process, so we're working through the details. Anyway, we're going to talk about the events today. The mini certification. I'll tell you a little bit about what we're doing. This course and the courses this week are actually part of 3 mini certification programs that we're launching. One is for UCC transaction, secured transactions. One of them is for financial statements analysis, and the other one is for credit and collection laws. So this actually falls into the secure transaction program. And how this is going to work is these sessions this week, we've got one more this afternoon, we've got 2 tomorrow and 2 on Friday. At the end of these sessions, we're going to give you a promo code. This is our first kind of paid certification program, and it's priced incredibly well at $199. But if you can make it to the end of the session, we're going to give you a promo code for 50% off. So for $99, you'll be able to take a look at this session, all the sessions this week, and also take a look at those sessions that have already been recorded. They'll be on the site, and we'll give you information on how to get access to that. So again, as I mentioned, today we've got Wanda Borges, who's going to be taking kind of the legal aspect of it, and Beata Egloff from First Corporate Solutions. And again, we're thrilled to have Beata. She's got incredible experience from the perspective of a service provider. Their company actually files UCCs, tracks UCCs. They do everything around the UCC filing process. So I think we've got some great insight that you're going to hear today. And as we go through this, what we'd like to do is kind of give you an overview of what is UCC and why do people use it? Why is it important? And at this point, I've passed control over to Wanda, and I'm going to have Wanda and Beata go through the slides and kick us off. Take it away.
Very good. And good morning, everybody. It is my pleasure to be here. I've been working with Hayako now for a couple of years, and it's a tremendous organization, and glad to see everybody that's on with us today. So very quickly, we're going to go through these slides, because what we really want to talk to you today about is some of the horror stories, or war stories, if you would, that both Beata and I have dealt with over the years. And the first thing that everybody asks, especially credit grantors who aren't terribly familiar with security interests, is, why do I want it? I'm selling on, open account, goods sold and delivered, get me a purchase order and I'll fill it and I'll sell to you. Why do I need or want a security interest? And here are 4 possibilities. You may be suddenly worried about your customer's financial condition, or you might have been selling them $25,000 a month a year ago, but now suddenly they're up at about $100,000 a month. And that volume of sales is getting you a little bit nervous as to whether or not you want to protect yourself. Or it could be a brand new customer, or maybe you've come out with a brand new product. You really want to push forward on a sales pitch, but again, cautiously, you want to have some security in order to do that. Beata, do you see your customers, your clients wanting security interests for these reasons and others?
These reasons and changes is huge. And sometimes we see that they haven't checked with legal counsel. So we also highly recommend, you mentioned a change in the customer financial condition, a change to the product. Like if they do a major change, we see sometimes it's not a huge new product launch, but maybe something that the company is considering more minor. And that too should revisit if you haven't been filing an UCC. Check with legal counsel on whether you should.
Thank you. So as we move forward, there are some very first steps that are absolutely critical if you're going to get a good, valid UCC security interest. My cardinal rule of credit is know thy customer. You need to know exactly who your customer is. Corporation, partnership, LLC, limited partnership, whatever they are, you need to know exactly what they are. Before you get involved with that, you need to find out who else is out there in front of you, and perhaps use Beata's company to run a UCC search for you and and a tax lien search, and find out who's going to be on top of me. If I want to be secured, who do I have to worry about? Take a look at your customers' financials. And you know what I've heard for many, many years? Oh, well, some of my smaller customers don't have financials. Nonsense. They all use QuickBooks, and they can print you up a P&L or a balance sheet from their QuickBooks and give that to you. It won't be perfect. It won't be audited, but it's financials. And then decide what collateral it is that you're going to take. And we're going to talk a little bit later about collateral descriptions. So collateral, what we used to say is it can be anything that you and your customer agree has value.
And in regards to the tax lien searches, just be careful. Some of your UCC searches will include a tax lien search and some won't. It very much depends on your debtor type and the jurisdiction in the state and where they're filing tax liens. So you can check with a company like us. You don't even have to use us for that search. You're welcome to reach out to me, afterwards. So just make sure that if you're doing searches, it includes all the data that you're looking for.
And that was a good comment, Beata. And it's true. New York, where I'm sitting right now, I can go online at my computer and I can run my own UCC and tax lien search. But there are some states like Delaware that you really need, somebody like Beata's company to be able to do that, because you're not going to be able to run it for yourself. So then as we move on, there we go. Oh, too fast. The controls are very sensitive. So some terms of the UCC Article 9 changed actually about 10 years ago already, but years ago, everything had to be paper, everything had to be signed. Today, almost everything on UCCs is done electronically. And the phrase that you'll hear is authenticate. And the interesting thing about authenticate is that the very first definition of authenticate is to sign. But it also says to use a symbol or encryption. In other words, electronic transmissions are absolutely acceptable and practical today when you're trying to do UCC security agreements and financing statements. My fingers have not gotten down perfectly yet. All right. So now I mentioned earlier, know who your debtor is. Well, the name of the debtor is so important, and we're going to have a war story about this, but make sure you know who your debtor is. If it's a registered corporation, you're going to find that with the Secretary of State. If it's just a partnership, not every state requires partnerships to be registered. You don't need a trade name. And in fact, with the revisions that were done, a trade name alone is absolutely not sufficient. So you want the full and perfect name of your debtor. If it's an individual or a sole proprietor or a personal guarantor, then in particular, you have to be very careful with what that name is. If you're coming after me with a security agreement, for example, you need my full name. So the example we use is Michael D. Larson. It would not be correct to use Mike D. Larson. It would not be correct to use Michael Larson. Whatever shows on his most recent driver's license is the name that must be used. A birth certificate can be used if that's what the debtor uses for his identification. Interesting to note, they don't say that passports can be used. They want driver's licenses or birth certificates, but they are not saying that passports are good identification vehicles. Beata? You nodded on that one.
Yeah, I couldn't emphasize that more. And we're going to give you some examples of where not using the full legal name has gotten some companies in big trouble, actually quite a few. So that couldn't emphasize this more. Whether it's an individual or a business, you need to get the name right.
All right, I see Michelle's noticed that Zoom is giving some challenges to somebody. Well, as they come in, hopefully those challenges will go away. So I mentioned that the UCC Article 9 was revised a little while ago, and that's where the revisions made sure that we are using the correct name for purposes and requires a surname, first name, and additional name. And what they say is the name has to be taken from the public organic record. And that may sound like a strange title, but a public organic record can actually be, for example, here, a registered organization is an organization that is organized strictly under the state laws of a particular state. And you find out about that corporate entity by looking at the public organic record, which really is the certificate of incorporation or the articles of organization for an LLC, or perhaps a partnership agreement for an LP. And you find that by going to the Secretary of State's site and therefore finding that public organic record in the Secretary of State's site, and you can pull it up, or what most of us do is rely on the Secretary of State to give us the actual name. But technically, you should get a copy of the certificate of incorporation. Now, I went forward purposely because I want you to get that idea of what that public organic record is. But now what we also want to know is, well, where do I file these documents? Your UCC financing statement must be filed where your customer is located. You cannot just file it where you think you should. Now, those of us that have been around forever know that in the old days, what we used to do was file the UCC financing statement wherever the debtor was located. So if we knew them at an address of 1 Wall Street, New York, New York, well, then certainly New York was where we would file. But what we find now is they specifically state you file where there's a location. And the location means if it's an individual debtor, it's either at their place of business, or if they have multiple places of business, you file at its chief executive office. So for example, now with individuals, it can get tricky. Take me. I'm an individual. Yes, my law firm is an LLC, but imagine if it wasn't. Imagine if it was Wanda Borges Law Offices. My office is here in New York. I live in Stamford, Connecticut. And when they're looking at an individual, they look at the principal residence or the place of business or multiple places of business at the chief executive office. Where would you file against me? Where I live or where my office is? And my recommendation always is file in both places. Belts and suspenders works every time. A registered organization, which I just showed you a moment ago, those corporations, they are located in the Office of State of Incorporation. Many, especially on the East Coast, many corporations are incorporated in Delaware. So you would say, well, Wanda, if the company is at 1 New York Plaza, New York, New York, I file in New York. No, if it's a Delaware corporation, you have to file in Delaware. And when I'm talking about filing, one thing I didn't specify, to be clear, everything you do with a security agreement starts with a contract. And that contract is called a security agreement. And you have to first have that written, signed contract. And then you perfect your security interest by filing a UCC financing statement with the proper location. So one without the other does you no good. Beata, how many times have you run into clients coming to you to fix a mistake because they filed in the wrong place?
Quite a few. And we also see this. It's so easy for a company. You have their mailing address. And, like First Corporate Solutions, we're also a Delaware corporation, and our mailing address is not going to reflect where you need to file.
So what the UCC did when it revised, it decided to come up with the rest of the world. And it now allows electronic filing pretty much everywhere. Generally, you file with the Secretary of State. You may have a designated office for filings. Beata reminds us that Oklahoma County has only one designated office for filing. And in Louisiana and Georgia, they still require filings in parishes in Louisiana, which for our purposes are counties, and Georgia in counties. And again, thank you for sharing that, Beata, that you can search them in both states, but where you get filing has to be very specific. So these next slides, I'm going to go through pretty quickly because we're not going to take the time other than to tell you these are bullet points of what you want on every one of your security interests, security agreements. You've got to name the debt. You got to define your collateral, decide what kind of coverage you want. You could have pages and pages and pages of warranties and covenants, default provisions, general provisions, and your remedies. So here is a very quick checklist for you. First, and after you have checked everything, security agreement, prepare it. Make sure you've checked your customer's name to be perfect. Make sure you decide what kind of collateral you want. Get the document signed or authenticated so it can be done electronically. It can be an electronic transaction. And then file your UCC financing statement. So there are two different types of security interests. One is a general security interest, where you basically get in line chronologically behind anybody else who has filed a security interest. The other is a purchase money security interest, where you only cover the goods which you sell or finance. It includes products and proceeds, which you can include on a general and security interest, but you must specifically put it into your verbiage. With a PMSI, a purchase money security interest, products and proceeds are there. You have the ability to become number one. And how is that? By notifying every prior secured party that you are about to enter into a purchase money security interest with your customer, you can leapfrog every prior secured party. But if you don't do the notification, then it's meaningless. So what you're doing when you have a PMSI, you've done your search, you notify. If you're going to mail it, which frankly, I don't recommend, and I don't think Beata recommends it either. But if you're going to mail it, certified mail, or some other, FedEx, etc., or facsimile transmission or electronic transmission is good. Do you want to add something to that, Beata?
No, I think you covered it in an excellent fashion, Wanda.
Well, okay, I'm trying to go through it quickly.
I know, we want to get to the meat.
Right, here is some verbiage that we offer to you. You can take it, you can use it. This is verbiage that you would put in your notification to your prior secured creditors so that they absolutely know you are going to leapfrog them and take number one. Here are your steps. Notify. They don't have to respond. Do your paperwork and file your UCC. Of course, the problem will come into play if, in fact, they do respond and say, no, you can't do that. But that would be a long conversation for now. Just to give you an idea, security agreements are very similar to ours in Canada. The Personal Property Security Act in Canada is virtually identical to ours. Of course, Quebec is the unique province in Canada. It requires everything to be in English and French. The security interest is called a hypothèque, and you need to get a local attorney. Beata, does your company do Canadian filings?
We do. We'll do Canadian and others as well, either searches or filings outside the US. And for Canada, I couldn't agree more. I've worked on previous projects like with PPSA filings and doing an integration to make them more electronic and quicker. And we worked with a local attorney for Quebec. So couldn't agree more about that.
Yes, great, thank you. So Mexico, has recently, it's several years now, adopted what they call a non-possessory pledge. And it is a secured interest, and it does extend over proceeds, and proceeds is automatic. So it's your goods and your proceeds. And it also covers future advances or obligations. You don't have to do it for every transaction. Like the US, you don't do it for every transaction. A PMSI is available, but just like here in the US, it only applies to goods clearly identified as goods belonging to or financed by the debtor. So here are some best practices that we recommend. Know your customer. That's my, cardinal rule of credit. Describe your collateral and train your staff to make sure that they know how important it is and what the best practices of UCC filings are. So with that, I think I'm turning this control back to Michelle at this point.
I think you are. I think that is true. Yes, ladies, thank you so much for a detailed description of how the whole process works for UCC. I think there's a lot of folks who understand it, but there's a lot of folks that don't, and this is kind of a new territory for them. So I think this is a great overview, and we appreciate the detail on that. So see if I can get the slide to go. Here we go. This is one more slide on best practices, I think, that I think we kind of already touched on here. Any other comments you want to make on this particular slide before we go into the next one?
Oh, I think we actually want to talk about the third point. Go.
To plan and file ahead. Yeah. we do recommend, as much as possible, plan and file ahead to minimize any closing or other delays during your process. And then also for continuations, file as far out as you can prior to the lapse date. You can file up to 6 months prior to the lapse date, and absolutely don't wait till the last minute. The states, their systems, they do maintenance, they can have system issues. There can be much larger issues, like if a state is putting in a new system, you don't want to wait until the last minute.
Absolutely. That's a huge topic that I think is worth discussing, which we're going to talk about in our next session on the war stories. So we actually had a lot of conversation about that exact topic when we were preparing for this session, because it seems to be just kind of ubiquitous out there. So it's an important facet to consider. So back again to our mini certification program. So hopefully you get a sense of what we're trying to do here at Hayako with kind of taking this to the next level is not only that certificate of completion, but also the mini certification. And this session today is the kickoff of the UCC filings mini certification. And we've got an additional 3 hours of material, 4 modules, and this is available to you and anyone else that comes to our site. Right now, this is our launch party for this, so to speak, and we're actually making this available to the general public for $199. But because you're on this session today, we will have a discount code for you at the end to give you 50% off. And we also are thrilled to get groups involved. So if you and your entire team want to be involved in this and each get your certification, we encourage you to do that. We're certainly open to making some discounts because this is kind of our launch, and we'd like to have people test it out, give us your thoughts, your feedback, what you think, what else we need to add to it, what other types of mini certification programs we could do. So a little bit about what's in the curriculum. Again, introduction to UCC filings, a little bit more about what we talked about today, the different types, mechanic liens overview, which we didn't really talk about much today. And we've got a whole host of information. Not only are there video tutorials, but we've got templates that you can download. Each of the modules actually has a quiz at the end. We have interactive scenarios to go through. And again, at the end of that, you'll actually get your nice little completion certificate with the mini certification badge on that you can easily add to your LinkedIn profile, which goes with you wherever you go. And the beauty of this is it is all self-paced. So when you log on to Hayako and you sign up for these programs, whether it's the certification program on UCCs or any of our tutorials, it is really watch these tutorials as needed at your leisure. The idea behind this was really to make kind of the YouTube of commercial credit and collections. So if you're at work and you've got a question about UCC, you want to find out something, you can quickly go on our site, search very quickly through all the material that we have, and literally find a 2 to 5 minute module to answer exactly the question that you have that day. Or you can, peruse these sessions at your convenience during your lunch hour, after work, while you're floating around in the pool on the weekend, or whatever you're happy to do. And we want to make this as easy as possible for you to consume. So it's at your convenience, at your pace. There's no rush. So this is for those of you who have not actually received a certificate of achievement or a certificate of completion. This is essentially what these certificates look like. And maybe on one of the future sessions, or if you're on LinkedIn right now, you could actually go look at a couple of folks. In fact, I'm going to just call out Rodney Skinner. You can find him on LinkedIn, and he's actually completed 8 of our courses. And you go down to the certificates and license sections on LinkedIn, and you'll see that he's got all these certificate of completion from Hayako Academy. Click on it and you'll actually see the certification pop up. So that's what it looks like in real life. And this particular program, when you actually go through this mini certification program, you'll get a fancier certificate that is not only completion, but actually a certificate of achievement, that you've actually gone through all the modules, you've answered the questions, you participated in it, and you get a nice, pretty little badge to add to your LinkedIn, your Facebook, and of course, your Twitter, if you are so inclined. Okay, so now we're going to get to the really, really interesting part of this is war stories. We have a lot of conversations when we're doing these sessions about what happens in real life. And I think this is kind of always the best part of any presentation, is when you get to talk about things that actually really happened in the past, or things that you're involved with right now, and how, if only things would have been done a little bit differently, how different the outcome might have been. And I have to give a call out to Robin Walters. Robin is Director of Credit at Keithley Williams Seed Company. Robin also spent many years at Cisco Food Services in Houston. She's got incredible experience, both domestic and internationally. And she wanted to participate today, but she couldn't make it, but she will be on a session that we have on Friday afternoon. So please join us on Friday afternoon for that one. But Robin had a bunch of great stories and situations that she contributed to this. And we had Beata and Wanda kind of go through these examples that Robin shared with us. And so we're going to use a little bit of what Robin said. And we're also going to have a perspective from these two ladies as well. Okay, so one of the things that is probably the most common issue that we hear all the time is having the wrong debtor name on your UCC filing. Okay, I think we were going to have Wanda start out with some commentary on this one. You want to get us started, Wanda?
Yes, by all means. The debtor name, and I said it earlier, is so critical, and it's my cardinal rule of credit. If you don't have the correct name of your customer, of your debtor, you could completely lose. I changed the name slightly to protect the guilty, I guess I should say. But for
Right.
we had a situation with one of my clients is a cement company, and they had sold to an entity that they knew as Monaco Ready Mix Company, Inc. The credit application said Monaco Ready Mix Company, Inc. All their papers said Monaco Ready Mix Company, Inc. My client has a beautiful credit application, great security agreement. They get personal guarantees. Everything was Monaco Ready Mix Company, Inc. They filed it. They searched to see if that was in fact the true corporate name. It was. They filed under Monaco Ready Mix Company, Inc. And then lo and behold, after several years of wonderful business, the company stopped paying. When we went to foreclose on our security interest and we ran a search under Monaco Ready Mix, because we don't run a search just on the entire name, because the Secretary of State's are very funny. If you put in the entire exact name the way you want it, that's all it's going to pick up. So you throw in actually on your search Monaco Ready Mix, and we came up with another company called Monaco Ready Mix Supply Co. Inc.
And a classic mistake.
Yeah, and it turned out that there were 2 entities incorporated with the Secretary of State, one under Supply Co. Inc., one under Company Inc. And they, of course, came back and said, oh, but no, but the company to whom who gave you the security agreement, you put the wrong name, you filed the wrong, it's the other company that owns all the assets. we litigated and we ultimately got a settlement out of them because it was clear that they were trying to defraud. And many years earlier, another example we had was one of my clients was in the pharmaceutical wholesale business, and they sold to a pharmacy. And after 6 months, the pharmacy changed its corporate name. They never told the pharmaceutical wholesale company. And again, after about 2 years of doing business with the wrong name of the debtor, and they sued, the debtor came back and they said, oh no, we changed our name. So everything you sold to the other company, but you have no security interest. We told the court it was fraud, and the court agreed with us. They said, yes, they were trying to defraud you and granted us judgment. But that ended up taking about 6 months before we got the judgment. And that was then. In today's world, God knows, it would have taken 1.5 years to get the judgment. And once we got the judgment, they filed bankruptcy. So
Oh my
it
God.
took us, now we had to go into the bankruptcy court, lift the automatic stay to proceed on the judgment. We finally were able to proceed with the judgment, but we were always convinced that multiple thousands of dollars of goods went out the back door that our client never got its hands on, and lost a lot of money because in one case, the client didn't know that they had the wrong name. And in the other name, it was pure fraud on the part of the debtor that changed its name and never bothered telling the customer. I think we have another example that Robin gave us, and in that case, it wasn't the wrong debtor's name, but it was a wrong description. They described their goods as inventory instead of equipment. And they went before a bankruptcy judge, and the judge denied their claim because they said, and Robin at that time was working for a company that was in the food industry, and all of the kitchen equipment, the judge said that was equipment. You did not call it equipment, you called it inventory. Inventory is that which a company buys in order to sell to somebody else. Therefore, your collateral description was wrong. You don't get to name equipment as inventory. And her company was denied its claim and reduced to merely $6,000. So I think we
It
can
is
go
incredible.
to the next, go ahead.
Yeah, I was just going to ask both of you ladies, since you both have such a long history in dealing with this kind of problem. You've been looking at UCC filings and all the ones that went wrong for decades. And I would love to get your opinion, your thoughts on, the percentage of UCC filings that came across your desk or came to your attention, the percentage where the debtor name was wrong, let's just say 20 years ago versus today. Has that percentage changed any?
I don't think so, but yeah,
It's still just like the most common.
Yeah, the Uniform Commercial Code, it's changed quite a bit. There was the initial revised Article 9, and then there have been revisions since then. And the later legislation has more defined what the proper name is, but we still see a lot of names that aren't right. It's one of the top errors that we see, and it impacts everything. Like we have different services, and even the states do, where you can monitor changes to the UCC that go on record after the filing or to the business name. And if the name's wrong, not exactly right, then you're not going to get that service correct either. It really is one of the errors that are most frequent. There's a recent case with the Florida Supreme Court. I'm going to change the names a little bit too. We'll say that the name had Ocean Boulevard in it, and Boulevard was abbreviated.
Oh my God.
And then it was LLC. And that too, the opinion of the Supreme Court is that it's misleading, especially based on the Florida standard search logic. So have clients all the time ask, well, do we have to include punctuation? You know what, why not? Why not be as safe as you possibly can? Put the debtor name in exactly as it is on the entity documents. That's your safest play.
Makes perfect sense, which kind of leads us to our next category of stories is data entry errors, right? That kind of plays into Inc. versus incorporated, period. Do things like periods and other symbols or dashes, underlines, different things in names, are those a factor in this type of process?
Usually not. Usually judges have ruled that punctuation is not misleading if it's left out. But again, I would take the safest route, put the name in on your UCC filing, just exactly as it's registered with the state. For example, if it's a business, if it's an individual, exactly as it is on the driver license or the birth certificate. And yeah, errors, they can either be when you're filing the UCC, you have a typo, or they can be a jurisdictional error. So for example, if it's an error that you've made, a couple of things you can do to help with that is, of course, double check anything that you're actually, typing. Make sure there aren't any typos in it. Wanda talked about perfecting the filing. For perfection, you have to make sure that you get the debtor name, the secured party name, and the collateral correct. It's so important not to have a typo or any major mistakes in that. And then a jurisdictional error, one way you can help and even figure out whether a jurisdiction has made a mistake. While a lot of the jurisdictions, a huge percentage of filings are filed electronically, some aren't. The jurisdiction websites or the integrations that we have with the states, they don't cover all the cases of the checkboxes and what you can do with the UCC filings. So some filings are still filed manually. Some states, there's a higher percentage of manual filings just because of how their systems or the websites work. And a best practice would be, go on the state's website. Some of them have the UCC searches. Some of them are even free. You don't have to use a company like us. And double check after filing that everything is indexed correctly. And then you can also check that you really are in the position that you thought you were. And years ago, I had one example, probably the most egregious. I had a client and they had filed a continuation. They filed it correctly. We processed it correctly. The state was manually handling it. And, the state, all those UCC teams, they're human. We're all human. We make a mistake. And someone on that team had indexed the continuation as a termination instead of a continuation, which is a really big deal. And we were able, I reached out to the state. They discovered the error. They asked us, initially what we did, and we didn't do anything. But I reached out to the state and we were able to get it corrected. But it is important, especially for your most critical deals. Do that post search, make sure everything's on record correctly, the way it needs to be.
I think it's such an important thing. We were talking about that when we were preparing for this. Is I love that concept, right? Like do all those searches beforehand, find out what the options are, make sure that even after you filed it, that it actually is appearing the way that you intended it to appear. Wanda, I wanted to ask you a question, and actually really the both of you. Do you see much, is there kind of like a professional courtesy when something actually goes to court, or if there's something that happens where it's like, well, because you had an attorney file this, or you had a UCC filing service file it on your behalf, versus you as the creditor, is there any leeway? Do you guys get any special treatment other than a creditor, or does a judge look at that as like, sorry, if the lawyer screwed up or the UCC filing company screwed up or the creditor screwed up, it's just a screw up?
No,
get any?
To the contrary, not that they're being discourteous, but by the time we get into court with a security interest battle, everybody is trying to pick what they can get. And I'll give you a perfect example of that. PMSIs, purchase money security interests, very strict requirements. You must notify and you must file. And in the case of inventory, you have to file before they get the inventory. In the case of equipment, you have a 20-day grace period. But you get into a bankruptcy court in particular, and one of my clients sells appliances. Well, they sell their appliance, which has their name all over it, but General Electric Credit Corp does something called floor planning. They also sell appliances, including appliances that have my client's name on them. And we And while we were polite to each other and we were courteous to each other, we both stood in court saying that the appliances in that store belong to me. And I said, no, we have a purchase money security agreement. They belong to me. And the attorney said, we never got the notification. And I said, oh yeah, here's the certified mail receipt. Yeah, you did get the notification. And then they said, oh, then they belong to you. So no, when it comes to once you're in court, you are fighting to get the best you can for your client. And courteous, yes. Give in, heck no.
Amazing stories. Now, this is kind of the next topic. Oh, before we go on to the next slide, I wanted to also throw out to everybody on the call that I think some of our Zoom issues have been resolved. So you have some additional stories that you'd like to chime in with. We actually have a decent amount of time left with us today. So if you have a situation that you even want to ask these lovely ladies about, you've got some experts here at your disposal. So encourage you to either put a question or a comment in the Q&A section or in the chat box, and we'll open that up to you as well. And this week we touched a little bit before, just on I think one of the prior slides, we kind of got into the erroneous collateral description. Anything that either one of you would like to kind of add to this topic?
The war story that Robin shared with us was actually a good war story. She said that she had a customer that bought some appliances, and the customer failed and walked away. But actually, to the contrary, she did not have erroneous collateral description. She had a good collateral description, and along came a new purchaser and said, oh, I see those belong to you under a UCC. So gave in and said, go ahead, you can take them. So that was good for her. But on the collateral description, it's also the revisions in the UCC actually allow you to file a UCC saying all assets. I hate that. It's legal, but I hate that. So, you get into an all asset situation and somebody's going to come along and say, well, yeah, but all assets mean all physical, tangible assets that you can touch and feel, but it doesn't include intellectual property rights, and it doesn't include trademarks, and it doesn't include patents. So I frankly hate using the all assets, and I make my clients have a very detailed collateral description. There's another important reason to have a proper collateral description. Once there is a bankruptcy filing, your security interest, if you are a secured creditor, you are on a higher level in the bankruptcy court, and you are going to get paid on your secured interest to the extent your collateral exists. So, for example, I had one client who sold and rented inventory and equipment to a customer. They filed bankruptcy. My client was owed about $130,000. But what they did the very first day of bankruptcy, they sent their salesperson in to take an inventory. And what came back was, because they could identify their collateral item by item by item, they were able to come back and legitimately say, our inventory that is on hand is only worth $86,000. And they were granted a secured claim for $86,000. So it is so important to have good collateral description, because then you can identify and you can grab. And the same thing with my appliance situation. My client had all their names on everything. If you're dealing with something that is rather unique, then you may even want to go so far as having serial numbers to make sure that those serial numbers are the ones that you're going to get back.
Okay, I got a question related to collateral description. Is there a limit on how many characters or how many items can be listed in that collateral description? way back when everyone had to use the actual form and you had to fill in the form, it was, like about an inch tall. And you had to kind of squeeze everything into the teeny tiny form. I think that's what caused a lot of people to say all assets and hereafter acquired property. But now that things are electronic, and most things are done electronically in most states, what are some of the guidelines for how detailed can you get? How much can you put in there? What are the options regarding that?
As much
Go
as
ahead, Amanda.
necessary. Yeah.
As much as necessary.
That came about, the first revised Article 9, that included that you could now say just all assets. Although, Wanda, you'll be probably happy to hear most of our clients don't use just all assets, but
Really?
they do frequently make mistakes. You want to make sure, first of all, that your security agreement, whatever that agreement is for, that the filing matches. And the filing isn't something that's really generic, that doesn't quite match the security agreement. That's going to cause problems if it ever goes to court. And then we also frequently see, not just on the initial filing, but there are a lot of mistakes on the collateral amendments. So for example, somebody will check the box on the filing to restate. That means you're replacing the collateral, but the description they have in there is just maybe something they're adding, or they're saying, we had a few loans, we're terminating interest in just this one item. Well, on a collateral restatement, whatever they've put for that section, that's what the collateral now is. And I see that quite frequently. It's a pretty common mistake. And then there are collateral limits as far as the number of characters when you're doing electronic filing with some of the state systems. But if you have a longer description that doesn't fit to go electronically, it can always be manually filed. So, whatever legal counsel recommends is really what we recommend people do for the collateral description. Keep it, as short as you can, because you tend to pay per page with a lot of states. But on the flip side, you need to make sure it's complete, and it's going to be, if it ever goes to court, it's going to hold up.
Great. Makes sense. Thank you so much. Okay. So this is we got 2 more categories of questions to go. And by the way, we got some feedback. Thank you, Carol, Walton, Grizzle. Comment came in. All these examples are really great. They are definitely the things we need to look out for. So looks like we're on the right track with this, which is good. That's what we were hoping for. So our next category is the caution sign, proceed with caution. Let's see here. We were going to have, I think Beata was going to talk about this, about what are the danger signs? What do you want to watch out for?
Yeah, so there are a few, and I know Wanda had a really good example too in regard to releases. One case I did want to mention, and I'll change the names on this too. So a well-known bank, they gave third-party authorization to their debtor. There were 2 loans. One was for $1.5 billion. The other loan was to $300 million. And the debtor had paid off the $300 million loan. And the well-known bank, they gave authorization to the debtor to go ahead and file a termination for only that $300 million loan. Well, the termination was actually filed completely. So when this went to court, there was no longer any security interest. The judge said, you gave authorization to your debtor, you didn't double check that it was filed correctly, you didn't file it yourself. None of that mattered, right? That there was a mistake. At the end of the day, because there was a termination for that UCC filing, there was no longer anything on record, and they did lose on that $1.5 billion in regards to the UCC filing. So that's one of the more well-known cases. You really need to be careful. Be careful of doing third-party authorizations, like if you're authorizing your debtor to do something. We've found that's pretty frequent, especially when somebody pays off the loan. And If it's truly paid off, maybe you are safe to do that. Some of our clients are trying to save on the cost and have the debtors do those terminations if they want a termination on record. There's probably nothing wrong with that, but still proceed with caution. Be careful about authorizing a third party like a debtor who may not be as familiar with UCC filing. You're probably better off doing it yourself if it's a really critical deal like this one was. And then we also see it quite frequently, releases aren't filed correctly. If it's really a partial release that's happening, often with the way that UCC forms are today, you do that as either a collateral restatement or maybe delete. Just make sure you're doing that correctly. If any concerns, you're unsure, I would check with your legal counsel. It's truly the safest thing to do. And I know, Wanda, you had a great example and some great info about releases too.
Yes, and you actually gave a perfect lead in when you said check with your legal team. Because don't just check with your legal team, but do what they tell you to do. I had a client who had a security agreement and they had a tremendous customer. They were a great customer for many years. They were selling to this customer probably $500,000 a month, and they were fully secured. The customer came to them and they said, hey, we've been a customer of yours for a long, long time. We always pay you. We've always been good. You've got, cross-corporate guarantees. You've got security interest. But our bank, we're getting new financing, and they said they won't finance us unless all UCCs are terminated. So terminate the UCC, let us get the new funding with the new bank, and then, we'll come back to you and we'll give you a new security agreement. You can file again. They came to me and they said, what do you think? I said, no way in heck. Do not terminate that agreement. They've been a good customer of yours, but no, you've got to monitor them. You got to make sure they do come back. And lo and behold, they said, well, yeah, we trust them. And that was their first mistake. Their first mistake was not listening to me. Their second mistake was trusting the debtor. They trusted the debtor. They terminated their UCC financing statement. The debtor got new bank financing. Ultimately, within a year, ended up out of business. And my client was probably stuck with an over $1 million debt that they never got paid. So, and Robin, one of the stories she shared was that they also had a great customer, also were asked to release the filing, thought, okay, they're going to be a good risk, released the filing, and they got stuck with a $264,000 balance. So proceed with caution. When they ask you to release the filing, for all the wonderful reasons in the world, there's probably an underlying reason that they're not telling you about. And I would hesitate to release filings under just about any circumstance.
These are incredibly painful stories, and I'd hate to be the credit manager who released one of those things. That's horrific. Okay, so go ahead.
I want to interrupt. Yeah, I want to interrupt right there because you said I hate to be the credit manager who released. Credit managers who make mistakes. You've got people like Beata, and you've got other companies around, and Michelle, you have Jerry doing UCC for you. There are a lot of companies around, or your attorneys or yourself can run searches. Years ago, many years ago, I had a client and they had a security agreement which they had filed themselves. And after 5 years, they were supposed to renew, and they had renewed once. And when the next 5 years came up, for some reason, the credit manager forgot to renew and they filed bankruptcy. And the credit manager, when he heard about the bankruptcy, actually, I think I notified him about the bankruptcy. He said, oh, that's fabulous. We've got a security interest. We're a secured creditor. I said, really? And I ran a search and I said, you're a security interest, and it lapsed within the last 30 days. I mean, that's how close they were to having been a secured creditor. They did not renew their security interest, and credit manager got fired. And obviously they were into a bankruptcy for large debts, large money owed to them. So proceed with caution every step of the way. Don't let your security interests lapse.
Yeah, that's
Go ahead with the
scary.
next one, Michelle.
That's scary for sure. God, you'd hate to be the one responsible for that. So, good advice for sure. Okay, so our final category here is search tools. There's so many different tools out there that we wanted to make sure that we had a discussion today about what are some things that you may know about, what are things that you may not know about, what are the ways to use those tools. There's a bunch of tools that are out there for free. There's all the way on up. And so, Beata, you want to kick us off on this since you are from one of our fabulous service providers. You want to tell us a little bit about what tools you recommend to people in addition to your own?
Yeah, sure. So we've talked about making sure that you file in the right location. You also have to make sure you search in the right location. So that's top of the list as far as the best practice. I mentioned a little bit about tax liens. Some states, those tax liens for individuals, they're going to be filed at the county level. And some counties, they're very electronic, and there are counties that you can go on their websites and you can do a search through the index and file tax liens. Now, there are other counties you can't. And in that case, you can either contact the county directly or you can work with a company like us. But definitely at the county level, if that's where the tax liens are filed, you're going to have to work separately from a UCC search. That also needs to be the proper jurisdiction. It could be completely different index, completely different jurisdiction from where those tax liens are. For the UCC searches, a lot of the states do have websites where you can do those searches these days. Same thing with the business name searches. I can't think of a state that doesn't have a business name search that you can use to make sure that you have that name correct for the registered entities. On the flip side, some of the states also have the documents out there. There's always a danger if you're getting your entity documents from the client that they're not giving you the complete package, like if there have been amendments, if there was a name change. So the safest thing to do is to get the entity documents from the jurisdiction. California, a number of other states, those are examples of, you can go, when you do the business name search, you can also actually pull a copy of and download the images for those documents. Depending on the state, entities may file an annual report or a biennial report. Some of the states have those out there as well. Those would have any changes with officers, or might be a statement where they're saying there aren't any changes. But definitely for free, some of the states have those out there, and I would use those resources. Happy to help anybody. Like if questions come up afterwards, happy to connect on LinkedIn and help with any questions about maybe improving search practices or how to find certain things. And Wanda, did you have anything to add?
No, I actually, that pretty much covers it. You covered it perfectly. I don't have anything to add to that.
Fantastic. Yeah, it really is amazing, how far this industry has come in the last 30 years. So it's just incredible. If you need a tool, there's probably something out there that exists. A lot of times it's free, at least for the beginning part. So that's always good to know. And definitely those of you, I know a lot of you know Wanda, but if you've not yet connected to Beata, please find her on LinkedIn. We'll have her LinkedIn connection or her profile link so you can find her. She has been with First Corporate Solutions for a very long time, and she is incredibly knowledgeable. And she has seen thousands and thousands and thousands, probably hundreds of thousands of filings. And I think she's a phenomenal resource. And, Wanda and Beata, both of them are here and available to help you. And please, we encourage you to reach out to them. So, okay, we do have one question that came in.
Yes.
The next topic is, I don't know who asked this yet. I can't tell. What if a customer says that their bank won't allow them to sign a security agreement?
Yeah, we run into that periodically. I guess I'm on the legal side of it. Beata may not see that so much. And we end up having to work with the bank and get a subordination agreement with the bank. In particular, when we get that more when there are really two answers. If you're in a general security agreement situation and the customer says, I can't give you a security agreement because my bank says no, you usually can convince them, hey, we're going to be number 10 or 11. It doesn't matter to you. Or run your search. And when you find out you're going to be number 10 or 11, you may very well may say, it doesn't matter to me. We're not getting anything by taking this security interest. But if you're in a purchase money security interest situation where you could be number 1 over the bank, and candidly, that's usually where the bank says, no, I don't want anybody being number 1. You can, your attorney can negotiate with the bank so that you can agree with the bank, you will be number 1, but we will be number 2 over everybody else. And that's called a subordination agreement. And sometimes they're very easy to deal with. But I will tell you in 2 cases, one I had involved a company that was actually a Delaware corporation, but they were physically located in Idaho, and their bank was very obstinate. The other one was in Quebec. And that bank was, oh my gosh, they made us jump through hoops. In one case, it took us a couple of weeks to get the bank to understand, look, you can still be number 1, but we'll be number 2 over everybody else. And then what we also agreed with that same bank was, wait a minute, but give us something. So we ended up agreeing and doing a subordination agreement that we would get the first 75,000, and then they would get the next, and then we would be number 2 over everybody else. But with the other one, it took us 6 months of negotiation because, unfortunately, I hate to say it, but when the attorneys get involved, things get complicated. And it took 6 months of us going back and forth before we finally got a subordination agreement that everybody was willing to sign off on. But that's the answer. You'd end up having to get a subordination agreement, or just say, I give up.
Wow. Yeah. Kind of crazy. Well, this is great. We are actually a few minutes over time.
Yep.
It looks like we are about to wrap it up here. For those of you who are interested in diving into this subject more in depth, also wanted to just talk about this program. This is a discount code that we are offering for this particular program. That's got we've got 4 hours, 3 to 4 hours of additional content regarding UCC filings. We've got all kinds of great stuff in this program. So we'd love to have you take a look at that, and you'll get 50% off. And we have another session. This is session number 2 coming up this afternoon in 2 hours from now, mitigate credit risk with secured transactions. And we're going to have another fabulous roster of speakers. We have Chris Keel, who many of you know. He was the NACM economist for many, many years, and he has agreed to join us this afternoon for the session. We also have Pam Crank of the credit department, who many of you have heard from before, different sessions at events over the past years. And we also have Paul Hill, who's going to give us some additional perspective on the economic situation and what's happening with regard to consumer lending, which typically in some way, shape or form ends up impacting commercial lending. And he's a really interesting guy, Canadian. You'll like him. He's a lot of fun. And also Dave Schmidt. So that is our session coming up at 2:00 Central. And I think that looks like we've got all the questions that have come in so far. And looks like this is essentially a wrap. And Wanda and Beata, I want to thank both of you so incredibly much for participating in this, especially kind of the short notice that we had to pull this one together. I think we've got a lot of interest in this topic, and we will certainly be doing sessions in the future, delving even more detailed into these stories. And I think it's great for people to hear what actually happens in real life. It's one thing to talk about just, practice, read a book, get a training, but actually to hear what really happens when you don't actually take advantage of these tools or you don't monitor it. So any other closing thoughts from either one of you as we wrap this up? Wanda?
No, I'm good.
Beata?
Me either. Just very happy to be here with everybody, and don't hesitate to reach out if you need help.
Fantastic. Thank you so much, everyone, for joining us today, and join us again in 2 hours for the next session. And don't forget, on Thursday and Friday, we also have 2 more live sessions, and those are also free of charge, and we'd love to see you there. Thanks so much, everyone.
Goodbye, everyone.
Bye.